Hello, this is Penny and Betty live from P&B Corp, and we welcome you to another session of Indigenous Issues. Today we will be discussing the Aboriginal Restorative Justice System. Now, for those of you not familiar with this concept, the Aboriginal Restorative Justice System is quite different from the Canadian criminal justice system in the fact that it places a higher emphasis on healing the harm done by the offense and rehabilitating the offender back into society to avoid future crimes.
That's right, Penny. This system is very much reflective of traditional Indigenous views of what justice is or should be. In fact, there are many Indigenous elements that can be used in a restorative process.
Perhaps you could expand on that for our audience?
Of course. For example, the key element in the Aboriginal restorative process is generally a healing circle. Members of the community come together to talk about the offense and the impact it had on the victim and the community as a whole. The circle will include the offender, elders, and even the victim should they agree to participate.
Yes, what I found intriguing is that the circle also focuses on the offender and the underlying causes of their offense. For example, if traumatic experiences of abuse or drug addiction led to the crime committed. Such factors in the offender's lives would be identified and discussed within the healing circle. When it comes to the offender, many say that partaking in a healing circle was much more difficult than serving a jail sentence because they were made to face and accept the harms that they have caused.
In the aftermath of a healing circle, there is usually a process of deciding what steps should be taken by the offender to correct the harms caused by their actions. Some examples include the offender partaking in specialized counseling or treatment programs that are aimed at the impact factors that contributed to them committing the offense, as well as community work service and traditional remedies specific to certain tribes. But before all that, the decisions to allow the use of a restorative justice process can come at many levels and take a number of forms.
There are three main levels of restorative justice processes that the law takes into consideration. One is diversion programs, the other conditional sentencing, and the last one probation. For all three options, there would most likely be other conditions, such as strict curfews, restraining orders, and other rules that would be enforced as well. The offender must also accept full responsibility for the offense of the crime. The diversion program relates the closest to the Aboriginal restorative justice remedy because it allows the offender to participate in the restorative justice process if they are qualified.
Speaking of qualifications, the Aboriginal restorative justice remedy doesn't always apply to everyone. There are many factors to consider when applying this remedy in certain cases. For example, Penny already touched on this, but the offender must accept responsibility of their actions and the offense committed. In most cases, the offense shouldn't carry a minimum sentence, and if incarceration was required, the sentence shouldn't exceed more than 2 years. The last thing they take note of is whether the threat posed by the offender to community was minimal or not.
Also, when it comes to the diversion program, they take into consideration the GLADU impact factors, such as a troubled personal history of substance abuse problems when deciding whether or not to divert the offender.
That reminds me, our audience must be wondering how the restorative process came to be. Do you mind expanding on what exactly GLADU is?
Certainly. The 1999 case R versus GLADU, or more commonly known as the GLADU case, was a landmark decision made by the Supreme Court of Canada that strongly suggested lower courts to consider an Indigenous offender's background and make sentencing decisions accordingly. This was based on Section 718.2e of the Criminal Code, which states, and I quote, "All available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders."
See, what had happened was, in 1995, 19-year-old Jamie GLADU, a Cree woman, stabbed and killed her common-law husband, Reuben Beaver, in Nanaimo, British Columbia. Miss GLADU was heavily intoxicated and in an argument with her husband, where he admitted to cheating on her when she fatally stabbed him in the chest. She was charged with second-degree murder but pleaded to manslaughter. Miss GLADU seemed to show remorse and while on bail, received counseling for substance abuse and completed grade 10. However, due to the reason that Ms. Gladue was not living on the reserve at the time of the murder, the judge rules that Section 718.2e of the Criminal Code was not valid in her case. She was therefore sentenced to 3 years in prison.
Ms. Gladue appealed the sentencing to the BC Court of Appeal, who upheld the previous sentence, but felt a need to clarify Section 718.2e of the Criminal Code. Then the case reached the Supreme Court of Canada, who further explained that the intention of this section of the Criminal Code was to balance the disproportionate number of Indigenous peoples incarcerated in Canadian prisons and to implement restorative justice. This approach was a way to help heal injustices throughout Canada's history, like residential schools and economical dislocations that continue to affect the Indigenous peoples of Canada today. One thing the Supreme Court of Canada was clear on was its ruling that judges may not excuse an Indigenous offender from consideration of Section 718.2e based on their residence, which is what had happened in Ms. Gladue's case. However, in the end, the court upheld Ms. Gladue's sentence of 3 years.
It was this Supreme Court ruling that brought the Gladue rights into existence. In its ruling, the court stated that judges must acknowledge how Indigenous offenders' lives have been affected by decades of colonial oppression in an attempt to end the over-incarcerated Indigenous peoples in Canadian prisons. Seeing as, according to Statistics Canada, Indigenous peoples represented 27% of its prison population in 2016 and 2017, even though they only accounted for roughly 5% of Canada's total population.
Right. And Gladue factors for judges to take into consideration include effects of the residential school system, loss of cultural identity, poverty, poor living conditions, level of formal education, and more. The right to such considerations apply to all Indigenous peoples, First Nations, Métis, or Inuits, wherever they live and whether or not they are raised by an Indigenous family. So, Betty, what is your take on the Aboriginal Restorative Justice System?
Well, the fact that it focuses more on healing rather than the punishment is what I believe our justice system needs more of. I believe the goal of our justice system should be to ensure the rehabilitation of the offenders so they are less likely to commit future crimes. The mindset that we must purely punish and isolate our offenders from society will not only alienate them even more, but will have detrimental effects on our society, which is what we should aim to avoid at all costs.
I completely agree with you. The restorative justice system also helps to decrease the percentage of Indigenous peoples that are being incarcerated, which is really high. Without looking at the root causes of why the crime rate is so high in the Indigenous population in Canada, root causes like poverty, lack of formal education, substance abuse, emotional and mental trauma, and more, the system will continue to repeat itself. We must, instead of punishing the Indigenous peoples, help to solve these issues within the communities to prevent future offenses. If we only punish them, there will be no solution in the long run, as it will happen again and again.
All right, that is all we have here at PNB Corp today. Tune in tomorrow at 8 p.m. Eastern for our next issue, The 60s Coup. Thank you for listening.